All right, peace and blessings, everybody. It's Monday, May the 21st, the year 2018. Free Lazor in a California prison, I think he's been in there 35 years, has sent me a ton of mail. I mean, big 9x12 manila envelopes, a lot of regular envelopes. There's all kinds of documents inside these things, and most of them, not all of them, because I haven't got around to all of them yet, but most of them have been uploaded to his webpage on yearofjubilee.com. I'm going to be going through them, and the ones that I can publish, I'm going to be reading them into YouTube as well. And that's going to take a little time because there's so many. The first one I'm going to knock out is a 21-page affidavit from Free Lazor himself. This is, I think, Free Lazor telling his own story. He said that it was an important document. Now, not only is there a 21-page affidavit that I'm going to be reading, it's going to take some time to get through that. You can go download it and read it yourself if you want. There's also attachments like Exhibit A, Exhibit B, Exhibit C. I am not going to be reading through the exhibits. Those are included in the PDF file that's on his webpage. Just go to the Free Lazor webpage and you can download the 21-page affidavit, and if you look in that, you'll see the exhibits. I'm just going to focus on the 21-page affidavit in this YouTube video. All right, let's read through this and see what Free Lazor has to say. I don't know for sure, but I suspect he's going to cover what happened. First, being duly deposed, I attest and affirm that the following statements of fact are true and correct as evidence. Number one, from 1984 through 2008, a continuous campaign. Let me read that again. From 1984 through 2008, in a continuous campaign, a few hundred networked prison guards and other prison employees connected with them throughout 42 prisons, transfers at a couple dozen California prisons, have participated in a scheme to prosecute false rule violation reports, RVRs, CDC 115s, against me for the admitted purpose of causing perpetual denial of my parole release from prison. Now, when I first read that, that sounds like a bold statement that, you know, a lot of prison guards are conspiring against him. But if you watch the Prison Stanford Experiment, and you also read Zimbardo's book, The Lucifer Effect, How Good People Turn Evil, it'll describe to you what happens in the mind of prison guards when they come across somebody like Free Lazor. In addition to inflicting other pains on me, the scheme also included various mechanisms imposed by the CDC, California Department of Corrections employees, to prevent me from having any means to administratively appeal the false RVRs or to prosecute court challenges to remedy this scheme and this condition and the conditions surrounding it. The activities constituting the schemes are detailed throughout this affidavit. Number two, in mid-November 1984 in San Luis Obispo County at California's Men's Colony, CMC prison, CMC guard Mr. Peterson, physically attacked me without provocation, with violent force sufficient to nearly have broken my neck, requiring weeks in a neck collar. Within hours, several CMC guards approached me stating they learned I had numerous pending lawsuits against CDC guards at other prisons and promised they would have me set up with false RVRs and sent to the hole where they would have me murdered if I were to file a lawsuit exposing Peterson's battery on me. They also promised a barrage of never-ending false RVRs, rule violation reports, for filing CDC 602 administrative grievances against CMC guards in general, and especially against Peterson for his battery. Specifically, they repeated numerous times this day and in days following, for every 602 you file on us, we'll file 115s on you, implying they would falsify such reports, and assure I was found guilty, even while innocent of any misconduct. These 6 or 8 guards, coming to me day after day with these threats for weeks, then thinning out over months, assured me that they were networked with other guards throughout the whole state within CDC, and had the power and ability to carry out such a false RVR campaign even through prison transfers for decades, and that they would do so to cause perpetual denial of my parole, release from prison, and a life of unimaginable hardships in my prison time. Number 3. At this time, I have been in prison over 1 year. Let me read that again, I'm sorry. Number 3. At this time, I had been in prison over 1 year and had never gotten a CDC-115 RVR. My behavior, which had been consistent as essentially the best of a model citizen in prison, did not change for the worse at this time, nor at any time since then to the present, throughout 34 years. Number 4. Yet within a few weeks of that Peterson battery and threats on 12/8 of '84, I was issued and then found guilty of an RVR for the first time, and another for the same act followed in quick succession, and then a flood of them, dozens, sometimes several in one day. Whenever I had a fair and impartial RVR hearing, officers, fellow prison guards of the accusers, who were not connected with the network of the involved guards, I was acquitted of the charges of each RVR, but these were the exception to the norm. Number 5. My first 2 RVRs, and being found guilty of both, were for honoring Yahweh's religious Sabbath commands to not labor on our Creator's holy Sabbath days. Federal courts over California have ordered such RVRs to be dismissed and expunged. Mayweather versus Terhune, 328 F SUPP 2D 1086. But the CDC-CDCR staff refused to comply in my case. Number 6. Of the dozens of RVRs issued against me to date, 39 presently remain, most of which have had some religious persecution or religious punishment connection. That is, a campaign of punishment for my relentless stand for non-politically correct, true biblical Christian principles, values, and living. Number 7. Every RVR I have been found guilty of has been connected to and influenced by an overblown reputation innately connected to the name Lazor. My reputation as a prison litigator, lawsuit filer against CDC, and as an excessive CDC 602 administrative grievance filer, my reputation as such is exceptional, especially as a whistleblower against corrupt and criminal activities of CDC employees, in their own frequently stated estimation. Number 8. By statute, my parole release date was some 16 years ago, May of 1992, a mandatory parole release date unless I were a danger to the community, which I have never been, and there's never been any genuine evidence to the contrary. I have been denied parole, kept in prison all these 16 additional years solely due to these falsified RVRs, exactly what C.O. Peterson's fellow guard partners promised me in their own words in November 1984, as well as at many other times since by other guards in their network. Number 9. In November of 1996, Mule Creek State Prison, MCSP, Appeals Coordinator Tom Amig, who later rose to the position of high-ranking CDC administrator in Sacramento headquarters, pulled me privately aside and told me in no uncertain terms that due to my non-criminal history and realistically self-defense nature of my conviction, I was one of the few with my types of sentence, second-degree murder under Proposition 7, who actually stood a very good chance of being released from prison on parole over the next several years. But he added that I was spoiling that opportunity by filing CDC 602 grievances and appeals, and that unless I ceased forthwith, I probably would never get paroled for the rest of my life, i.e. mandatory 1992 parole sentence would be converted into a life without the possibility of parole, sentenced by CDC employee whims in misusing the CDC 115 RVR process as a reprisal system for my filing of CDC 602 grievances. This is one example among countless of the same assurances by CDC employees told to me many times since the 1984 Peterson battery incident. I never ceased filing CDC 602 grievances because it's been too unbearable to suffer the oppressions I'm under without an attempt to remedy them. Shortly after this meeting with Amig, he went directly to inmates Wilkins and Tashler and incited them to attack me with physical assault and battery, which Tatchler did, resulting in additional RVRs used to deny me parole for many more years, which is one of the RVRs in this petition where the hearing officer who pronounced me guilty participated in investigating and charging me with the alleged offense of mutual combat in direct violation of CDC Regulation 15 CCR Section 3320H. Number 10. Of the present 39 RVRs still outstanding, I suffer punishment still, to this very date, ever ongoing, daily, including parole denial for 25 years, misplacement in the most harsh, violent, restrictive prisons, and hundreds of extra special daily oppressions not usually present but for the RVRs. Every one of them has an identified nexus and motivation factor connected to my reputation as a lawsuit filer or CDC 602 grievance filer against CDC employees. Some CDC guards who violently, severely abused me have ended up arrested by the FBI with their CDC careers ruined, and some even imprisoned for homicidal crimes. Example, Sergeant M.S. Lemon, Michael Powers, et al. This is known by some of the network CDC employee abusers and held against me, including by their falsifying RVRs against me as reprisals for this. Number 11. From 1984 to date, 2008, the campaign of false RVR write-ups by CDC guards and other connected employees has continued unabated and actually worsened over time. Many more CDC employees have continued to join this network campaign over time. Hardly a month has passed since November of 1984 Peterson incident to present, roughly 300 months, when one or several inmates, often total strangers, have not approached me and informed me that they hear on a regular basis my name passed around among the prison staff with regard to being the most hated, most targeted, and sought-after prisoner for inflicting random abuse, even uniquely in a category all my own, unlike any prisoner they've ever heard of. From 1985 continuing through the past several months in 2008, I have been regularly informed by independent ear-eye witnesses that they've overheard guards, especially from MCSP, CO Beaufort May, particularly, telephoning their networked guard brothers, where I'm now incarcerated, specifically attempting to incite them against Lazor, me, to practice special targeted abuses against me without cause, and especially to carry on the campaign of issuing and finding me guilty of fraudulent false RVRs and other adverse reports, Chronos, and such, while knowing I'm behaving exemplary. Mr. May was heavily involved. Mr. May was heavily involved in numerous acts of this precise misconduct against me during 2008 until I left MCSP and phoning KVSP staff to continue this at KVSP per witnesses. Number 12. The practice of guards calling others of their loosely connected network at other prisons following my transfers have been going on steadily since 1986, to my personal knowledge, and which I have personally witnessed, actually heard, somewhere around a dozen occasions or more. It has also taken place from 1986 to 2008, of my personal knowledge, witnessed by slightly modified means, including by false witness reports passed on, by false malicious progress notes passed on and placed to be read in my central files and medical psych files, which I've personally seen guards access in violation of state law and prison regulations. The Wreck Lazor's Life message is also passed on by means of my CDC 602 complaints and staff's accusatory responses against me thereto, active at one prison and then reactivated at the next prison I've transferred to. This I've witnessed scores of times. It has also dozens of times been passed on by misuse of CDC 602 telephone interviews, where I'm summoned to the phone in the midst of between 2 and 8 guards to address on an open speakerphone over my objections, false accusations from staff, at the previous prison I was transferred from. The surrounding guards then have commenced the accusations, the attendant harassments, and activation of the false RVR campaign at my new prison. This has happened many times. Number 13. I've had 42 documented prison transfers, which is, I think it's up to 51 now, or is close to the CDC record for prison transfers, based on extensive research. Almost all have been based on retaliation for the Lazor hate phenomenon, either directly or secondarily connected with the name Lazor, always pronounced with a hard A, with a nexus to legal whistleblowing against CDC employees and with religious persecution undertones. It's observably as if a computer-like program has been planted in the involved CDC employee's mind to target and pursue Lazor with false RVRs and other reports with a vengeance. And when they find I'm a model prisoner, it's as if this programming compels them to create and prosecute false reports and inflict cruel, undue punishments. When the name Lazor is set around them with a soft A, this program-like response is not evoked as a general rule. Of the 42 transfers, each with few exceptions has resulted in the...
Who was the guy who was exposing derivatives of derivatives?
That was Kurt Johnson. My wife just asked me who was exposing the housing scandal and derivatives of derivatives. That's a man by the name of Kurt Johnson. He's in Marion Prison. And of course I'm banned from speaking with or communicating with anybody at Marion Prison. Let's continue with Lazor. Is it Lazor? I guess Lazor is a soft A and Lazor is a hard A, huh? Product that I've continued to generate monthly, almost daily since my imprisonment began, all in an effort to prove my innocence, be exonerated and released or released on parole, be exonerated of the false reports and to overcome prison obstacles. The confiscations and often subsequent loss, destruction, disposing of these files, including my only accessible copies of RVRs and 602s challenging them, parole transcripts and documents and conviction case documents, often under strict time constraints, legal deadlines, have kept me from accessing these legal documents for some two decades, continuously, as will be shown in specific detail below. Where I finally gained access to such documents which survived following months and years of confiscation, they've routinely been seized again and sequestered indefinitely, some forever, shortly after I gained access and had possessions only long enough to restart my legal work on them, but not completed for CDC filing or court filing. Number 14. I keep exceptionally meticulous and thoroughly detailed records of all significant daily events in prison which affect me, including my conduct, false accusations against me, declarations/affidavits from witnesses and involved parties, misconduct and involvement by prison staff in matters pertaining to me and much else. I have done so from 1983 to the present for various purposes, including supporting all of my allegations of factual events, proving my innocence and supporting my exoneration against false accusations, enabling the pinpointing of dates, times, names of involved staff, prisoners and witnesses, and specific details of events. These records verify, in many instances, when I prepared and presented for filing or to CDC employees initiated of and subsequent responses to CDC 602 and other dated legal matters. The staff campaign of ongoing confiscation and sequestering of these files, ranging from months to decades, as already described, as well as the described destruction disposal of them, has rendered it humanly impossible for me to identify, presently and often forever, if I had presented CDC 602, what dates I did, to whom it was given, or by what means mailed, including the 602 appeals of RVRs. This is the sole reason. Hold on.
He's out of town. Call his brother.
You know what? I'm going to pause. Let me get to the bottom of the page. If I had presented a 602... Okay, this is the sole reason for my inability to identify with pinpoint accuracy the exact dates and usual staff names I delivered such documents to, and if I did so, because of all my records of such events have also been confiscated and disposed of in the course by CDC staff. Number 15. For certainty, I have never been remiss on a...
Free Lazor.
This is free Lazor right now. Okay, I'll have to take it. All right, peace and blessings, everybody. We're going to pick up where I left off. Free Lazor called in the middle of reading his affidavit. Number 15. For certainty, I have never been remiss on a single CDC 602 deadline of challenging any RVR I've gotten. Whenever I received the RVR, I diligently prepared and timely presented, filed by sending in the mail to appeals coordinators, my required CDC 602 challenge of every RVR ever received in CDC. In numerous instances, CDC staff refused to provide me a copy of the RVR, sometimes for months, sometimes never, until I obtained a copy years later from state files, the Attorney General et al. When such non-service to me occurred, it always violated CDC mandatory regulations binding on staff to present it to me within 5 working days. Title 15, California Code of Regulations, CCR, Section 33201. Piggybacked upon that frequent staff failure, appeal staff from the lowest level at the prison I was at to the highest level CDC Director's Appeals Chief in Sacramento, almost without exception, refused to allow me to file a 602 appeal whatsoever without the RVR attached, while knowingly and deliberately refusing to provide me a copy, which they had ready access to and could easily have provided me at any time. Number 16. In those instances just described, which were anywhere from several instances to 8 or 10, when I ultimately obtained a copy of the RVR many months or years later by extraordinary tenacity, without let-up, in spite of my proof that appeal staff refused and barred my earlier appeal of the RVR within 20 working days of the hearing disposition, and that all involved staff refused me the RVR copy, for all those months, years, appeals, staff nonetheless permanently barred me from ever filing my administrative appeal as a matter of unqualified right, abrogating forever my challenge of those false RVRs. The courts then barred my petition from being heard as to these due to failure to exhaust administrative remedies, in spite of the CDC staff obstructions just described. Number 17. I've amassed over 300 sworn, affirmed declarations and affidavits from eyewitnesses attesting truthfully to the events described above. That's an amazing statement he just said. Let me read that again, even though I want to get through this. Number 17. I've amassed over 300 sworn, affirmed declarations and affidavits from eyewitnesses attesting truthfully to the events described above. Number 18. In all or almost all of the instances described in paragraphs 13 through 16 above, I consequently filed 602 grievances challenging these staff practices, often being required by them to file 10 or more different 602 grievances just in order to get the initial 602 addressed. This is the norm, wherein appeal staff demand that I challenge and seek to entangle countless knots and obstructions, bars, locks, and impediments seemingly without end, in order to be allowed to proceed further on the merits of these 602 appeals and grievances, until it had long ago reached the state of being a full-time effort and more than full-time, i.e., it would take more hours than exist in a day, every day, just to meet these appeals coordinators' demands, whereupon, meeting them, they impose another barrage of them without end. Many years ago, it had already been gotten to the point where it required more than 16 to 18 working hours in a day to keep up with even 20% of the demands put on me by CDC appeal staff, just to get through their obstruction gauntlets to have my active 602 grievances appeals heard on their merits. Despite my diligent attempts to the contrary, most of these 602 appeals have been permanently screened out, i.e. procedurally barred, always without legitimate cause. Number 19. From approximately 1997 to the present, 2008, it's actually 2018, so he wrote this 10 years ago. There have existed less hours in a day than necessary to meet the demands of the CDC Appeals Coordinator obstructionist gauntlet to have my 602 appeals addressed on the merits and exhausted concerning RVR challenges and other related grievances. Prior to that, 602s I filed challenging RVRs and others were more infrequently lost after I presented them to CDC staff and never returned to me. When I tried to begin the process over again, which I did in each instance, as soon as I learned it was lost, CDC appeal staff barred me from being late or successive when I did not file late, and the only successiveness was based on staff having lost my first timely filed appeal. Number 20. On a few occasions over the years from the 1980s and on into 2000 decade, one or more courts have barred my court challenges of a given matter, not necessarily an RVR challenge, citing to their presumption that the action they were barring could have been completed in a shorter time, as though that were the only legal case deadline or obligation I had. This is erroneous in that nonstop since the 1980s to present, there has never been a day that I have had less than actually hundreds of vital legal obligations to complete, and all being worked on at the same time. They have continued to ever expand, to grow in quantity and backlog every day to the present. These literally hundreds of simultaneous high-priority legal demands and obligations every day for the past 2+ decades are in addition to the dozens of simultaneous administrative appeals demanded by the appeals coordinator at all prisons I've been at for the past 12 to 15 years or more, as described in paragraph 18 above. Some typical examples of essentially endless streams of such demands from the prison appeals coordinators are when the appeals coordinators refuse to process the initial 602 grievance appeal without certain papers attached, even though they are totally irrelevant. The only way I can hope to obtain those papers is by filing another 2 or 3 602s to various other prison staff, as they won't provide them otherwise. Those are also blocked by the counselor, record staff, visiting lieutenant, litigation coordinator et al., demanding I must overcome some other obstacle first, which can only be done by additional 602 filing with other staff, and on goes this process. This is now the norm and has been for many years, and this process is multiplied as much as 50 times at once due to over 50 backlog 602s on for over a year and obstructed over a year by the appeals coordinator. Recently, this was going on with 51 such appeals at once. This is much more than a full-time job for 4 people, and I am only one person with other legal obligations too. Up to now, all courts have barred me from untimeliness on any matter, having failed to take this into consideration. From 1999 to 2001, while denied legal access to almost everything else, I spent almost all waking hours of every non-Sabbath day just trying to obtain and organize all my past 602s in order to have proof of exhaustion attempts, only to have them seized, sequestered, and disposed of just before completion of this 2.5-year-long process. I've since not been able to obtain copies of them again to date, despite exhaustive, diligent efforts. Number 21. The entire administrative grievance process permanently malfunctions into a total perpetual standstill shortly into the process described above due to the requirements of Title 15 CCR 3084.4a, prohibited filing of more than one 602 in any given 7-day period, nor can any be filed after passage of 15 working days from the date of inception of the triggering event. 15 CCR 3084.6c. By these two provisions interacting together, the administrative appeal system has been completely closed off, shut down permanently as to issues such as those described herein, including RVR challenges. My court challenges to this for years have resulted in complete denial of a remedy. 22. These obstruction gauntlet practices have proven to usually require much more demands on my time, energy, expertise, and resources than the prosecution of the average court action, such as a habeas corpus petition, mandamus, prohibition, or civil complaint. Number 23, a complete list of active high-priority legal demands upon me daily from the 1980s to the present, 2008, which I've diligently been working on or trying to prepare for court filing and prosecution, could fill dozens of pages of single-space typing just by a one-line heading list. Since more come into existence each week than can possibly be eliminated, the list grows each month exponentially. A brief sampling includes: Point: 4 past parole hearing petitions for writs of habeas corpus, each being a full-time job under prison restrictions. Point: 4 separate and disrelated challenges to my criminal conviction and sentencing based on newly discovered evidence, fundamental changes in the law, past impediments to filing earlier, provable actual innocence, and 18 major issues in the main habeas challenge, each requiring hundreds of hours of legal research that I've been barred from sufficient law library access to complete from 1986 through 2008. Point: more than 30 RVR habeas petitions, each one being nearly a full-time job. Point: more than 50 tort civil actions for false retaliatory RVRs that have wrecked my life and lost me my entire life, including the past 16 years in prison, when, by law, I was free to be on parole. Point: 4 different parole challenges, not 4 past hearings, but challenging the nature of the sentence and sentencing infrastructure itself, each separate action showing that the properly applied sentencing scheme of the statute I was convicted and sentenced under required me to be released from prison in 1992, with my sentence fully served at that time. Point: more than 30 crucial medical health urgency habeas petitions and more than 30 related tort civil actions for irreparable damages to my body, genes, my future, including the gross shortening of my lifespan. Each of these actions purpose to stop further destruction of my body, health, and life, which is occurring daily until such court actions can be prosecuted. Point: more than 25 retaliatory-based transfers, which, until stopped, will continue to perpetually disrupt and sabotage every legal action I've activated and am attempting to activate presently. Point: about 15 tort and civil actions for staff brutality on me directly and setting me up to be brutalized and murdered by other inmates, resulting in lifetime brain and neurological damage, and many other damages to date. Purpose to stop all further such violence against me. Point: more than a dozen legal actions to prove I've been barred from sufficient and meaningful law library access or other legal facilitation as required by law in 14 different prisons from 1986 to 2008, continuously, and to obtain a remedy for my continued imprisonment solely due to this obstruction and its many ramifications. Legal actions for remedy and compensation for CDC staff stealing and destroying 26 of my personal approved typewriters, and the losses and damages from not having them, and the court actions ruined by those acts by CDC staff. Point: relief from ongoing episodes and compensation for losses and damages of over 80 documented major acts of robbery of my personal and legal property by CDC agents, including theft of legal files resulting in extra decades of my life destroyed in prison as a factually innocent prisoner, and irreversible destruction of my health and shortening of my life by these thefts. Point: numerous religious rights violation actions which the U.S. Supreme Court has recognized as constituting irreparable harm. Point: several hundred different specific cases embarked on but not completed of being barred from access to the courts by illegal, unconstitutional, obstructionist tactics and scams by CDC officials. Point: hundreds of administrative 602 appeals and grievances filings not yet addressed or completed and required by the courts for exhaustion purposes, to redress the literally hundreds of separate episodes of unconstitutional, extreme, inhumane abuses carried on weekly throughout essentially my entire imprisonment. Point: others too numerous to continue listing. These alone demonstrate that thousands of hours per day are demanded of me to work on these actions, which I have been doing nearly nonstop for over 2 decades. I've exhausted myself seeking legal assistance for these, as of yet to no avail. Number 24. On November the 10th, 2001, I was attacked by inmates who had been solicited by CDC employees for my reputation for filing administrative complaints and had my head stomped in repeatedly. This resulted in significant brain damage, adversely affecting my memory, conceptual capabilities, and impairing my ability to analyze material, including legal cases and other aspects of legal work. It also adversely impacted all other aspects of my life. That has further retarded and impaired progress in every area of my life. 25. During the entire period of 1983 to 2008 while imprisoned, I've continued nonstop as my first priority in life to complete my very complex petition challenging the validity of my conviction sentence and imprisonment. This work, like all else in my life, has been constantly thwarted, sabotaged, and my months and years of legal work product repeatedly seized by CDC staff for years, then disposed of, destroyed, and lost. Each time, year after year, usually several times each year, I had to begin the whole project all over again, and often without access to the old witnesses, data, and research product that I'd spent years gathering in the past. This project alone was enough for 4 or 5 competent, experienced legal professionals working full-time, and this carried on in the status for 18 continuous years before I was able to complete the petition and file it before CDC staff seized and disposed of it again. Every week of my life, virtually nonstop from 1984 through 2001, almost all of my waking hours were invested in the side-track necessities of battling CDC staff and their obstructions of this project in order to get access to my seized, lost, sequestered legal files and related administrative appeal efforts. Those 602 appeals consisted of mainly efforts to overcome the obstruction gauntlets at every turn. Health emergencies, which also retard and stop my legal progress, piled up RVRs, and ever-escalating avalanches of CDC staff reprisals, many at the point of inhumane oppressions. Even 2% of these could not be worked on in my limited 24 hours existing in each day. 26. My conviction challenge has still not been heard by any court due to misapplied procedural bars. I am still investigating many hours of my every month of my life in trying to overcome that illegally imposed bar so that my factual innocence petition can be heard for the first time. 27. Since 1984, continuously to the present 2008, work on my top priority conviction challenge has, of necessity, had to compete with massive amounts of time every month invested in the burgeoning files of false RVRs, with scores of other legal work demands. Most of those attempts have been to get past the endless gauntlets of CDC obstruction against my efforts to complete these legal cases for court filing. Of the relatively small amount of court actions I did get filed over these 24 years, every one of them was sabotaged by hundreds of CDC obstructions that proved impossible for me to overcome. A small sampling of these obstructions is specified throughout this affidavit. Example 42, disruptive transfers, over 80 robberies of property, including legal work, product files, many hospitalizations near death with roughly half-year recovery periods of disability, each staff brutalizations, dozens of confiscations of my property, including legal work product, loss and disposal, destruction of my legal files, hundreds of 602 administrative grievance appeal filings obstructed with endless schemes demanding hundreds of hours on my time per day. Specifics concerning RVR fraud, scams, staff abuses thereto. 28. As to every RVR I've ever found guilty of, I was plainly informed that the specified punishments imposed by the hearing officer, judge, adjudicator was the maximum punishment I could or would ever receive throughout the remainder of my life. I was informed forthrightly that none of the RVRs, neither severely nor cumulatively, could ever be used to extend my actual time spent in prison, and that not one of them nor all of them combined could ever be used to extend my actual time spent in prison, and that not one of them, nor all combined, could ever be used to deny me parole and release from any prison at my MEPD minimum eligible parole date of May of 1992. 29. Every RVR I've ever been found guilty of has been used both severely and cumulatively to deny me parole on my set release date of May 1992, and every day since then to the present, ongoing presently. Every day of this has been in excess of the total punishments imposed by the RVR hearing officer in every RVR I've ever received, and all combined, and likewise in excess of any judicial decree of imprisonment time by a jury or judge, or any judicial branch entity. 30. Beginning in 1985, shortly after my first RVR in December 1984, and continuing to the present 2008, prison guards have confiscated my only copies of my RVRs, and my 602 appeals of the RVRs, and my legal work product in petitions in progress to challenge the RVRs, confiscated before they reached a state of completion for court filing. What few I did get filed in court. CDC staff then sabotaged every one of them by way of hundreds of obstructions which provided impossible for me to overcome, regardless of my diligent attempts to the maximum of my capabilities. Those cases were let die by default or withdrawn for inability to prosecute or lost by inability to present and argue the merits of my case meaningfully. 31. The quantity of my RVRs I was working on simultaneously without let-up, including efforts to overcome staff obstacles to my progress, grew from 2 in 1984 to 7 in 1985 to 14 in 1997, and eventually over 40 I've had to continue working on, all simultaneously, over all these years to the present. Those guilty finding challenges were in addition to often more than full-time work in preparing defense for the RVRs hearing themselves, several hundred hours each on the average. This included tracking down witnesses and interviewing them, waiting in line many hours, many days to access someone or something, including law library research materials, relevant records, and preparing defenses, and much else. 32. In 1983, CMC staff began a campaign which has never stopped through 2008 of confiscating, stealing, destroying, losing, and otherwise dividing me from access to my personal typewriters approved me to have and obtain at my friend's family's expense. In 1983, friend Kirk Lee sent me an approved typewriter, which R&R staff illegally sent back without ever telling me, in violation of CMC rules. This sabotaged my legal work progress due to the handwriting damages, limiting my capabilities to less writing than that required to meet my legal demands. Let me just offer a commentary. I have a really hard time reading Lazor's handwriting. It's some of the messiest handwriting I've ever seen. He blames it on his brain damage. Similar acts were committed repeatedly thereafter, each time requiring quite a few months to get another typewriter sent in again. The next one, or two typewriters, staff threatened to throw down the stairs next to the R&R offices at CMC, and upon transferring to San Quentin, the typewriter arrived, appearing to have been thrown down a stairway, in staff's own words. Eventually, each year, up to about several months ago, staff stole, lost, or destroyed 26 of my typewriters, all documented, and each time requiring months of efforts and hardships to get financial resources to obtain the next typewriter. An average of more than one per year was taken or destroyed by staff by illegal, unconstitutional misconduct. Each episode prejudicially impeded the timeliness of sabotaging my legal work progress. 33. During many or even most of my 42 transfers, it's up to 51 transfers now, staff lost or disposed of much of my legal property, including irreplaceable legal files, work product I've spent years working diligently on. This included the 40-plus RVR challenges and numerous different attacks on my criminal conviction. 34. On many occasions of various different RVRs, CDC staff refused to provide me a copy of the RVR which, refusing to let me file the required 602 administrative appeal, challenges its property without the RVR attached. No matter how much I tried, I could not get beyond the staff obstacle. My 602 complaints about this obstruction only resulted in more false RVRs issued with guilty findings as reprisals for my complaints. Once the 15 working day period passed, after the RVR's guilty finding was rendered, CDC appeal staff permanently barred me from ever appealing that RVR, thus abrogating my codified absolute right to administratively appeal every RVR, Title 15, CCR, Section 308.1a, 308.4.1a. 35. Exactly which RVRs fall into this category of CDC staff having forever barred my right to administratively appeal them cannot be determined now solely because of staff seizing and disposing of my meticulous, accurate records of those events. One such verifiable event, representing others, occurred on 3/22/06. Okay, I'm going to get to the bottom of this page, which is the bottom of page 11, and we'll read the remaining 10 pages tomorrow, but let's at least get to the bottom of page 11. When litigation coordinator Earl Canepi took 34 boxes of my critical legal files, 2 decades worth of what survived other staff takings, which staff had accumulated over about 20 years by continuous seizures on sequestering, building up the quantity every few months with more seizures. These contain 23 years of legal work product restarted over and over again and irreplaceable proof of exonerating facts. MCSP, PNR, R&R staff handed them over to Canepi, who disposed of them, which I have official records to prove, even after Canepi carried on efforts to conceal those records for 2 years. 36. One typical example representing various others of CDC staff attempts to permanently thwart and bar my right to appeal a most critical RVR that falsely accused me of violence that would cause parole denial for many more years, ended in an atypical resolution only because of an unusual counselor who had recently been assigned to my case, Miss Valenzuela, at CSP-CEN in 1999-2000, while at PBSB out to court from CSP-CEN on 7/4/1999. I was set up by prison guards to be murdered by white power gang inmates. I was jumped and brutalized and accused by a false RVR of mutual combat, and, as usual, found guilty. For months, I diligently attempted to get the RVR to enable me to administratively appeal it, and was denied. Ultimately, Counselor Valenzuela belatedly got me the RVR copy, and appeal staff barred me from filing, because it was late. I filed immediately, within a few days of getting the RVR. After much wrangling by me, Valenzuela finally took the extraordinary steps of intervening and convincing PBSP Warden Mr. Ayers to deem the appeal timely and to hear it. Ayers personally investigated, heard the 602, granted it, totally exonerating me of any wrongdoing as solely the victim of the attack. In doing so, he proved his understaffed guards knowingly lied and covered up their fellow guards' misconduct in the false RVR prosecution against me. Despite this exoneration, this RVR was nonetheless used against me to deny parole in my parole hearings of 2000 and 2006. 37. At least several other RVRs I presently still suffer under, never-ending punishments and ongoing parole denial, were similarly situated to this one, in that I had been accorded my codified guaranteed right to prosecute my 602 appeal of them. My actual innocence would have been proven. Yet I still suffer under the wrongful guilty findings. Number 38. In a number of instances, court policies and practices have continued to prevent me from having my habeas petition heard, which challenges false, fraudulent RVRs, because CDC staff barred me from exercising my codified guaranteed right to administratively appeal these RVRs as just described above. This continues, though I have done everything possible that I can imagine on my part, and all that is required of me by law, to prosecute my 602 appeals. Number 39. The RVR's challenge that I have prevailed on by being exonerated and having them dismissed has been at the cost of hundreds of invested hours of time and energy, efforts and resources for each one, to the exclusion of being able to work on other RVR cases and my own conviction case, parole cases, and others. These each have gotten bumped out of line by all the time and resources I had in any given month and year and decade devoted to those other ones. I could only work on so many, and that limitation necessarily prevented work on other ones still waiting now for me to have time for them. When we pick up this tomorrow, I'll start at the top of page 12. All right, we're going to pick up at the top of page 12 and see if we can't get to page 21. Exactly which RVR challenges have been bumped by this and energy limitation dilemma, there is no way to determine, solely because of staff taking and disposing of my records with all that information. See paragraph 35. 41. Specific periods and events of confiscation and disposal of my legal work product files. The following are from notes which did survive, relating to specific staff seizures, sequestering, stockpiling to build up the quantity, and disposing of my legal files over the past 2 decades. This is only a small sampling of many other episodes. 1986 at San Quentin, kept stored in C or D section for staff conveniences until sent to R&R Depot and kept there during January through February 1987, and again in April of 1987 until transferred with me to CFM on 6/1/1987. From 6/1/87 to CMF, kept in R&R storage through November 1987 until transferred to Atascadero State Hospital, ASH. From November 1987 at ASH, kept in storage there until transferred to CMC, and then to CMF in May through June of 1988. From June 1988, the bulk of it remained stored outside my possession and access until transferred back to ASH in 1990. Point. It remained stored away again at ASH and CMC between January and August of 1990. Point. During some period in 1990 at CMC, guards forced me to throw out boxes full of irreplaceable legal files, asserting it was quantity excessive, including RVR files, conviction case files, and much else, largely irreplaceable work product. Guards randomly chose what to take and dispose of when I proved unable to move fast enough to suit them, or to choose some to throw out. Of what remained, some was stored outside my possession and access until I transferred back to ASH on 6/6/1990. From 6/6/1990 at ASH, my legal files remained stored outside my possession and access until I transferred back to CMF on 8/15/16 through 1990. From August 1990 at CMF, I possessed some of it, but much of it was stored at R&R, without which I could not completely, hardly any, or any cases for filing until November 1991, when even what I possessed was seized and sequestered for the next 8 months, while I was bounced from one psych wing to another and nearly died of cachexia. Anybody know what cachexia is? Cachexia. On 7/7/82, I was transferred to CCI, while I was dying of cachexia in far gone stages, and psychiatrically hospitalized as a result, during which time all my legal property was stored outside my possession and access until I was transferred back to CMF for critical emergency medical intervention in August 1992. From that August 1992 period at CMF, all of my legal files remained stored in staff custody outside of my possession and access for 1/4 year until I recovered and transferred to CSP-SAC on 11/15/1992. Point. From 11/15/1992 at SAC, most of it remained stored by staff outside of my possession and access until I transferred on 6/8/94 to CCI again. You know what? I just got to look up what cachexia is. He said he almost died of it, so I'm curious what it is. CACHEXIA definition. It says cachexia is weakness and wasting of the body due to severe chronic illness. All right. At CCI again, as I lay dying of cachexia, a repeat of the 1992 transfer here, all of it remains stored at R&R outside of my possession and access, except several boxes full that Warden Jerry Stainer ordered R&R guards to seize and mail out of the prison to my designee, or be destroyed. Several such boxes full of documents were mailed out, never to be seen again by me, the same as if he had destroyed them on sight. Point. During July 1994, I was transferred to PBSP, and my surviving legal files followed me. A large portion of it, again, was stored at R&R Depot, outside my possession and access, without which I couldn't hardly complete any of my cases being worked on, except a few new lawsuits to keep me from being murdered. I was under a hit contract by solicited inmates by guard Michael Powers and others who were convicted of crimes of this sort thereafter. This status continued until I transferred to MCSP on 10/20/1995. From October 1995 at MCSP, most of my boxes of legal files were stored at R&R outside of my possession and access, and ongoing denials of access month after month in violation of the prison's own written policy for access, until transferred to CSP-COR on 3/7/97. From March of April to 1997, the CSP-COR, most of my boxes of legal files remained stored outside of my possession and access, regularly being added to by additional takings from me, where weather critters destroyed some of the boxes full until I was transferred on 11/25. Where weather and critters destroyed some of the boxes full until I transferred on 11/25/97 to SVSP. From November 97 at SVSP, many of these boxes of my legal files, enough to deprive me of the capability to make such progress on any of my cases, remained stored by staff outside of my possession and access until I was transferred back to CSP-COR a half year later on 5/5/98. From May of 98, for the next 8 months, these boxes of my legal files once again remained stored at R&R outside of my possession and access until I was transferred again on 9/22/2000 to CSP-LAC. From September 2000, CSP-LAC, the boxes of my surviving legal files were stored at R&R outside my possession and access until 7/30/2003, or shortly thereafter, when I transferred to HDSP. From late July or early August 2003 at HDSP, with the exception of about 1 day, essentially all my boxes of legal files, with all my ongoing work product of the past many years, which survived, was kept in various storage areas at HDSP. There, while under the property officer's custody in the PHU unit, Officer Gonzalez or Rodriguez, some 6 boxes full or more, most of which were critical legal files of conviction challenges, RVR challenges worked on for about 20 years, and parole denial challenges, were stolen along with my family Bible, irreplaceable family photos, and other priceless items, and never seen again. The property officer admitted only he had access to this stolen property. The theft occurred within several weeks prior to 11/20/2003, when I was transferred with what survived of my legal files back to MCSP. Okay, I'm going to stop at the top of page 14 and we'll pick up later. Okay, picking up at the top of page 14. From November of 2003 at MCSP through 32306, various amounts of these boxes of legal files, by far most of, at all times, remained sequestered at R&R outside of my possession and access until I transferred to KVSP on 32306. Point. During the quarter of a year prior to this 32306 transfer, the MCSP notable events concerning more seizures, thefts, and destruction of my legal files and other property took place in successive waves as follows. Guard Miss Lucas, Lieutenant Blim, and inmate Scotty Wright, CDC number J-44215, headed up a group of guards who from December 2005 through March of 2006 regularly hit my cell every several days, sometimes every other week or so, seizing and permanently sequestering more legal work product. As I continued to produce more work, they continued to be permanently confiscate more, citing it as quantity excessive. Guards Lucas and her partner, Miss Brown, deliberately handed over boxes of my personal and legal property to inmate Scotty Wright to steal, sell, trade with other inmates, and trash. Wright prodded Lieutenant Blim to throw me in the hole without cause, whereupon all of my surviving legal property was seized and stored in various areas of the prison illegally, including unsecured in the education department. Much of it was never recovered. Point. 32206, the day before the transfer from MCSP to KVSP, all newly generated and regained property in my possession was again seized and packed up for the next day transfer, except some of these were merged with 30-plus boxes of my legal work sequestered for the past 19 years. These were herded up into 34 boxes full and disposed of by Earl Canepi, MCSP litigation coordinator, in a staff action unprecedented in CDC history as verified by CDC records. During the morning of 32306, MCSP inmate Joseph Garcia, CDC number HO1695, delivered to me a large plastic hefty garbage bag full of my personal property. He had recovered from the Lucas Blim's guards' campaign to loot and destroy my property. This contained critical legal work product, many years of efforts, and much irreplaceable documentation. Upon being called for transfer, I handed this property to guard Mr. Poog, who handed it to guard Mr. D. Hammond, which I witnessed, who never put it on the transfer bus as supposed, and it has never been seen since. From 32306, upon arrival at KVSP and transfer from MCSP, and for an unknown amount of weeks following, KVSP staff reported that they had lost, my boxes of legal property, which had been stored with the ADSEC property officer, a staff enemy of mine, named Mr. Mesa, or similar spelling. Some was eventually covered, but not all. Within several weeks of receiving the surviving legal files, before I'd had the time to complete any of my legal casework, mainly focusing on a deadline parole denial petition, I was again sent to the hole. Without cause, and all the legal files I had were again taken from my possession and access. For the next several months, I lay dying of cachexia. I looked that word up, and it means to waste away. I had a nervous breakdown from overwhelming staff abuses. During September 2006, most of my boxes of legal files were returned to me, but some were lost, some looted by guards, and by then I was mentally incapacitated, unable to adequately perform legal work for the next few months. Still, I tried almost daily with my focus necessarily on my parole denial petition. Most of my RVR files and past parole hearings files and conviction case files had by now been disposed of by CDC staff. I continued on this course, focusing almost exclusively by necessity on my most recent parole denial challenge until I transferred back to MCSP for the third time on 32907. From March or April 2007, upon my property arriving at MCSP, most of the surviving boxes of legal files were immediately seized and stored at the R&R depot. most of what still remained stored outside of my possession and access. Without regular access, I could not make any legal progress on essentially any of the legal actions. There they remained with access denied in violation of MCSP mandatory regulations until I transferred yet again back to KVSP on 8/20/08, straight to the hole again without cause, where access to my legal files were restricted and denied. Upon transfer from MCSP to KVSP on 8/20/08, Sergeant Minnick at MCSP R&R seized over 20 boxes of my legal files and additional personal property, including backup files I'd sent out of prison for safekeeping over the years, sent back to me in piecemeal bits at a time. These files had been refused to be sent to me by Minnick and his partners in this scheme, all the way up and including MCSP Warden Mike Martell. Upon transfer arrival at KVSP, I was placed at the hole again without cause and kept there with access to most of my surviving legal files denied me, until released from the hole on October the 23rd, 2008. Many items were stolen while in ADSEC property storage. 42. During these 20-some years of re-seized, sequestered legal files, I'm gonna have to stop on 42. All right, we're gonna work our way through this free Lazor 21-page document come hell or high water. Let's start off with number 42. During these 20-some years of re-seized, sequestered legal files campaigns, including continuing presently, at some points I was granted limited qualified access to some, not nearly all, of the files. This ostensible, occasional access proved to be a pretense and formality without substance. When I needed access, I was denied at staff's whim close to 100% of the time until it was too late to salvage what I lost. And the particular files and documents that I sought, I was denied almost 100% of the time. Staff, by systematic design of the seize and store scheme, assured that my boxes of files would remain in a state of chaos, unindexed, disorganized, and rotting boxes with the bottoms falling apart, and making me lift these more than 100 to 150 pound boxes with a damaged, diseased spine. As such, it required, in almost every instance of ostensible access, more hours to ever find what I needed in the scattered dozens of boxes than what I was ever afforded. And due to my mental disabilities from prison abuses for over 1/4 century nonstop, I often couldn't mentally endure more than a few hours of such file searching. There were times of accessing over 20 boxes at once, all open, and their contents sprawled over a large holding tank. When I was demanded to throw all the papers in random boxes, more disorganized than previously because I had to be extracted right then for some prison emergency, this happened more than once or twice. Since then, years have been required to reorganize them, and I've never been allowed time to do that. Nothing can be readily found without the reorganizing and indexing. The result of the factual events presented in paragraphs 41 and 42 above are that in 23 years, 1985 through 2008, I have never been allowed to access all my legal documents necessary to complete petitions for my RVR challenges for parole denial of 3 different parole hearings, and my highest priority conviction challenge of provable factual innocence. Denial of replacement copies of lost documents required to proceed. 44. Commencing in March 1986, all my legal files that I possessed in my cell were seized and stored away outside of my possession and access, many of them forever, never to be recovered. From then until 2008, every several weeks or months, more of my legal files continued to be seized frequently and sequestered until disposed of. From this inception, March 1986, I began requesting of my prison counselors, CCI, their supervisors, CCII, then program administrator supervisors, records custodians and their supervisors, associate wardens, and others to provide me with copies of the RVRs, Administrative 602 appeals of RVRs, parole documents and transcripts, and other legal and CDC documents necessary for me to challenge all RVR, parole denial, conviction, and other matters. Form 1986 through 2008, only 2 counselors granted my request for copies. In 1986, at San Quentin, Richard Howell, CCI, provided documents I sought, but before I could complete and file court petitions for them, they were again confiscated by staff and not returned. See paragraph 41 above. In 1994, after being denied my request for these documents and file reviews by at least a dozen counselors and record staff from 1987 through 1993, Mark Stambuck, CCI, finally provided the copies I'd requested. However, shortly thereafter, before I could make any significant headway in preparing a petition based on these documents, these were seized, and then I was transferred to CSP CCI, where Warden Jerry Stainer ordered these documents destroyed or sent out of prison. They were taken by the guards, and I've never seen them since. These and all other safety copies of documents I'd sent out of prison for safekeeping to family were all destroyed by the major Central California flood that hit the San Luis Obispo area in 1995. 45. All my other counselors and I asked every counselor I was permanently assigned, and all record staff from 1986 to 2008 acted on my request as follows. Point. Some said they were too busy and would try to arrange it sometime in the future, and then scrambled to have me moved off their caseload or yard. Gloria Williams, CCI 1993 through 1994, Miss Venezuela, CCI 2000, Miss J. Priest, CCI 6/15/2006, Miss Gibney, CCI 2007 through 2009, Mr. Garza, CCI 2008 et al. Some outright refused, stating I already received the initial copy of each document and therefore had no entitlement to another without regard to the fact that some I had never gotten as mandated. And others staff had permanently confiscated illegally after my receipt of them. Kathy Clark Johnson, CCI, 1995 through 97, Record Supervisor, 86 through 2008 et al. Point. Some outright refused, admitting they didn't have the time to deal with my massive many volumes of now 10 central files. Mr. R. Trujillo, CCI 1994 through 95, Record Staff et al. Point. Some provided a limited amount of copies, far less than requested, and needed to carry on my legal casework, lacking the most critical documents I requested, without which I couldn't proceed. Some provided only front sides of two-sided documents, rendering them useless. Both sides were needed. Several times over the years they requested back the one-sided copies for reference to get the back sides, and never returned the back sides nor the front-sided copy. I relinquished to them, leaving me nothing once again. Valenzuela, 1999-2000, Mr. Witt, CCI 2006 et al. Point. Others, most frequently after months and even years of wrangling with incessant request and finally grievance filing, provided only a partial file review, about 5 to 10% of the documents I needed to review, as a pro forma pretense, and after waiting months, often over 3/4 of a year, for the copies I'd spent hours identifying and tagging, they finally informed me that because I was indigent, which is my permanent state while in CDC, they were refusing me all copies of anything from my files. Kathy Clark Johnson did this repeatedly during 95, 96, 97, each time again promising she would provide them if I were to spend the hours tagging them, which I did each time. At least 15 other counselors, many record staff personnel, have done this between 86 and 2008 repeatedly, with this avenue continuously foreclosed by CDC staff, and there have been no way for me to obtain the required RVR documents, 602 appeals of the RVRs, parole hearing transcripts and records, and other legal documents necessary for me to challenge these matters on the merits administratively or in the courts. Mr. R. Trujillo, CCI 94 through 95, Miss A. Acosta 2002 et al. Others. My files were unavailable for over 6 months at a time. The Attorney General's office at times illegally took the entire C files into their possession for over 6 months at a time, so that neither myself nor CDC staff could access it. E.g. DAG Mr. Cash Dollar 2001 through 2. Timely filing of 602 administrative appeals for exhaustion. Point 46. Number 46. I have timely filed CDC 602 administrative appeal for every RVR I have ever received in CDC. However, many have at some point in 2 or 3 stage process been abrogated and sabotaged by CDC staff to where they couldn't go further, or were aborted by being lost while in staff custody. In every such instance, appeal staff have refused to refile or reactivate the appeal process when I tried, instead killing the process and my right to appeal. This has been achieved by a number of different means, sometimes by staff returning the 602 with critical and non-replaceable pages missing, without which the process is dead, also by them losing the 602 entirely, then refusing to allow refiling. Also by sitting months turned into years on my 602s, finally resending the appeal back to me, demanding non-existent or non-accessible documents be attached before I can have it processed. By sending my appeals to other prisoners who never returned them, just as I frequently received other prisoners' 602s inordinately often mixed in with mine from the appeal staff, by appeal staff refusing to process a 602 due to documents I've attached, citing them as excessive, yet without which I have no support for my field, by incessant abusive screenouts which consume months and years of my time in a perpetual game of never-ending screening out by guards, rolling up all my property without notice, including active 602 grievances, appeals under deadlines, refusing to let me access them until their 15 working deadline expires, after which the appeals staff permanently bar it as too late without regard to time tolling, and a host of other schemes to completely abrogate a genuine administrative grievance procedures availability. Number 47. Where I theoretically may have been able to file habeas petitions in the courts where CDC staff prevented my exhausting the 602 appeal of each RVR challenge on the merits, I was informed until recently that, to the contrary, this is not allowed by the courts. I was informed of this by case law, by various legal treatises and prisoners' rights type book, by court clerks and judges who barred my petitions on the basis that without exception, if I did not have the merits addressed at the director's level of CDC 602, I am thereby barred to prosecute a petition in the courts concerning that issue. Number 48. Aside from that just stated in paragraph 47, more often what has prevented me from court filing of my RVR challenges on the merits until this instant petition, which is not on the underlying RVR merits, is that without access to the RVR and 602 challenging the RVR, I could not remember what my issues were for a particular RVR. With my notes seized and disposed of, and with the ongoing passage of time at each level of the 602, the staff routinely delays their response over the codified time constraints, which is the norm, frequently exceeding a year for all levels. I could not remember my issues. This has been exacerbated by my having 40 RVRs petitions to prepare all at once, as they have built up, and due to my severe brain injury on 11/10/2001 that adversely affects my memory and analyzing it and paperwork capabilities. This is why the copies of the RVR and 602 I initially always filed have been an absolute necessity for me to prepare a court petition challenge, and why denial of such copies by staff have prevented my capability to prepare and file those petitions. The instant habeas petition has not required me to access 602s I filed to these RVRs, because the petition is a pure law, only excess of jurisdiction petition, which does not involve the underlying merits of any of the RVRs. Number 49. The only way I did obtain the RVRs to attach to this petition was by an attorney, Stephen C. Sanders, Sanders & Associates, 3960 Industrial Boulevard. Aaron, did you hear that address? 3960 Industrial Boulevard, Suite 100, West Sacramento, California, 95691. He obtained them from a filing by the Attorney General opposing my parole due to them. Since Mr. Sanders sent them to me in less than 1 and 1.5 years' time, they have seized from me by CDC staff on at least 4 different occasions, at least 3 of those times requiring me to obtain them again from Mr. Sanders' firm, with no end in sight as to how many months or years they would be sequestered by CDC staff. These ongoing confiscations, along with this entire case file of my ongoing work product, has impeded my progress time-wise, just as over every year for the past 2+ decades, I finally have been able to get outside people to hold safety copies, and by this means have finally only now been able to overcome this unconstitutional impediment. Number 50. In addition to my legal files being sequestered illegally for some 2 decades, preventing my capability to prepare and file legal challenges of the RVRs, parole denials, conviction challenges, and other legal matters, CDC staff has also repeatedly and deliberately destroyed and abetted in the inmate thievery of my legal files, mixed with other valuable personal material items of property, on over 10 well-documented occasions. I've collected over 300 sworn or affirmed affidavits and declarations from eyewitnesses to occurrences of staff sabotage of my meaningful access to administrative and court forums for remedies, and of CDC staff reprisals against me for being Lazor, the legal beagle 602 lawsuit filer. Many of these include witnessing staff deliberately destroying my legal files, including my RVR challenges, parole denial challenges, and conviction sentencing challenges, including the following. Point. In 1988 and 90 at CMC prison by several guards at the R&R depot trashing boxes of my legal files. In 93-94 at CSP SAC prison several times trashing my legal files directly via inmates. This included guard Mr. White turning over all my cell property to inmate enemy Robert Kelly, CDC C-59443, for Kelly to steal whatsoever he wished. In 97-98 at CSP COR, several times by guards at R&R, who issued the ultimatum that I either reduce the quantity of my boxes of legal files by trashing some, or they would randomly do so. About 5 boxes full were destroyed. This way, on one occasion, at least 4 boxes full again on another occasion. In 1994 at CCI, as already described, where Warden Jerry Stainer ordered boxes of files taken and mailed out or destroyed. In 96, 97, 2004 through 2006, 2007 through 2008 at MCSP, some of which have been described above, MCSP staff worked in conjunction with inmates on several occasions to allow them to loot boxes of my personal property, which also contained legal files. In 2006, correctional officers Lucas and Brown left boxes full with specially favored inmate Scotty Wright, never to be seen again, on January the 18th, 2008, and again on May the 22nd, 2008. Guards Mr. May, Baker, and Wilkinson set at least 10 boxes of full of my legal files and other personal property in the 5-building day room and left, leaving them to be looted by inmates who, according to sworn witness testimony, carted off whole boxes full in order to get them to their private cells, where they could pick what they wanted and trash the documents to destroy the evidence of their thievery. In 2000, Sergeant Miss Johnson, with 6 other guards, trashed hundreds of my legal papers, pulling them from my cell, sweeping them across the day room floor and into trash receptacles in front of dozens of shocked witnesses, at least 6 of whom testified to this by sworn affidavits. Number 51. My central files of 10 volumes containing over 10,000 counted pages have proven to have had critical documents illegally removed over the years. Hence, the files does not presently reflect complete accuracy as to vital matters of what I did or didn't timely file challenging RVR's parole denials and other matters, as the proof has been tainted by removed documents. 52. I have continued to file CDC 602 appeals challenging both old and more recent RVRs right up to the past or present year, based on new law and newly discovered evidence I couldn't have previously known, even with due diligence. All such 602s have been rejected, screened out as untimely, though there was nothing untimely about them on these basis. Number 53. I have been continuously since 1992 sent to California's worst, most violent, abusive, terrifying, and deadly prisons through the present and ongoing still. See Exhibit Y, number 20, 26, 29, 31, 35, 38, 40. At the time, each was deemed by most standards to be worst, and treated with the harshest mistreatment in the state's prisons, according to more than 300 sworn affirmed witnesses. In that course, I have been repeatedly set up to be brutally murdered on various occasions, shot twice, viciously attacked under CDC staff directives to inmates, have permanent brain damage and nerve damage from severe head stomping, and other damages due solely to having an artificially elevated point score from the false fraudulent RVRs at issue in this petition. Number 54. Ever since the day of the Peterson battery on me in November 1984, except for brief lulls until this networked guards learned where I was following transfers, I have been uniquely, specially targeted of a loosely connected network of CDC guards and other employees connected with them, much like the prison guard gang, the Green Wall, and been specially subjected to a 25-year-long campaign of what was initially violence, terror, and harassment by hundreds of guards who only needed to be told that I'm the target in order for them to join in, like having been passed a baton in a relay race. The violence terror campaign eventually distilled down to primarily destroying my life by false RVRs to keep me perpetually denied my due parole release. This perpetual parole denial by false RVRs is precisely what Correctional Officer Peterson's fellow guards promised me on the day he violently attacked me. It precisely follows the specific course those guards promised in terms of what they would achieve through their statewide network of guards throughout the CDC system. For the first time since 1984, it appears that as of October 2008 at KVSP, this network is somewhat dissolving except for some lingering traces. Number 55. I have exhausted every administrative remedy that has been made available to me as to every RVR at issue in this prison without fail and on time, as described in detail throughout this affidavit and petition. Number 56. In the past 23 years, 85 through 2008, I have never refrained for even 1 month from trying to obtain the required and necessary RVR and 602 appeal documents in order to complete the habeas petitions, this and others, to challenge all the RVRs I have ever received, but could not prevail any sooner than now due to the gauntlets of obstructions never ending as presented throughout this affidavit and petition. Number 57. During the past several years, roughly 2007 through 8, the Americans with Disabilities Act, ADA, a federal statutory codified law, has identified and come to recognize a psycho-emotional disability referred to as legal abuse syndrome.
Yep.
I don't doubt that for a second. Let me say that word again.
Getting it just listening.
Yeah, legal abuse syndrome. I have that, and I've never been to prison. I already have it, so I can totally agree with Lazor. The disability consists of an emotional, trauma-based condition from being subjected to extreme emotional, psychological abuses from injustices and rigors of the judicial system in America. For over 2 decades, I have been trying to describe a psychological disability under which I suffer, and have suffered for over 20 years, which is precisely the legal abuse syndrome. This condition has contributed markedly for over 20 years to my inability to have done more sooner on this instant petition and overload of many others. My experience has been akin to someone who has been brutally raped repeatedly, where there has been so much psycho-emotionally damage that they literally actually cannot force themselves to confront the matter of sex even in a beautiful, gentle manner due to the ingrained trauma. Similarly, my trauma from legal abuse in CDC and the courts for 26 years, beginning pretrial for my imprisoning case, is so extreme as to have consumed most of my waking days and nights for all those years, and it imposes psycho-emotional barrier, an actual block that impairs and prevents pushing through the trauma of making legal progress. It is as strong as an actual physical object serving as a restraint, but often harder to overcome or remove. The trauma associated with producing this affidavit has been so powerful of a blocker that it has taken me about 1/2 a year to write to this completion. While it has been my #1 top priority and all legal matters during that period, producing a comparable affidavit not impaired by this trauma disability would take me no more than several hours in one morning compared to 1/2 a year of daily pushing myself here. I, Free Lazor, attest and affirm, subject to penalties of perjury by state and federal law, that the facts presented in this attested affidavit are true and personally known to me to be correct, and that if called as a witness in any legal proceeding, I could competently and truthfully testify by affirmation as to these matters. This affidavit, made the 20th day of November 2008 in the county of Kern, K-E-R-N, California. Okay, this was done 10 years ago. I mean, I'm going to cry. He's been in prison 35 years. If he suffered this much trauma 10 years ago, I mean, he's been in prison 35 years.
Oh my God.
That's a shocking thing what I just read. I pray that you reach out to Lazor with a letter of encouragement.
I feel nauseous.
It's making me feel like I want to vomit too, but write Lazor a letter. Let him know that you love him, you care about him, and that you're praying for him, and that this life is just a blink of an eye. We'll all be in heaven soon. Thank you for your time.